Okay, it's a little bit. Okay. Ja, aber ich mache die Tür zu.
I think you can begin whenever.
Okay.
Sorry, could you change my name to Ursula Kriebaum? Because I think I cannot do that. Or at least I wouldn't know how, because I never entered Professor Anna Petrig. So this was done by whomever.
Yes, can you just say your name again?
Ursula Kriebaum, Professor Ursula, Ursula,
Ursala, yeah.
Ursula, Ursula.
Yeah.
Kriebaum is Kriebaum.
Oh, sorry, just kind of broke up. Krie?
Baum.
Gotcha. Okay, perfect.
Yes, that's it. Yeah. Great, thank you.
No problem.
Well, good afternoon, good morning, or good evening to the panelists, all stemming from Europe. A warm welcome to this afternoon's panel entitled Arbitration of Human Rights at Sea, Giving International Law Teeth by Empowering Victims to Enforce It. My name is Anna Petrig. I'm a professor of international law in Basel, Switzerland. And since a great deal of my research turns on human rights at sea, I have a great pleasure to moderate this panel. Awareness about human rights violations at sea is growing. The topic increasingly receives media coverage and is more often than in the past subject of academic research. Right now, a major concern is that the COVID-19 pandemic has put seafarers around the world in a very precarious situation. Our first presentation, delivered by Elisabeth Mavropoulou, will provide us with some factual background to better understand the problem of human rights violations at sea, and she will also highlight some advocacy efforts undertaken in this field. From the factual level, we will then move to the legal level with Professor Papanikolaou elaborating on the legal framework protecting people at sea. She will inquire into the question whether there is a problem of a lack of law or whether the problem is rather a lack of enforcement. I reckon that Professor Papanikolaou will conclude that the lack of enforcement is at least part of the problem, if not the major problem. Indeed, as regards the implementation of human rights, Mary Robinson, the former United Nations High Commissioner for Human Rights, spoke, I quote, of a failure of implementation on a scale that shames us all. And she made that statement in the land-based context. In a maritime context, the problem of implementation, enforcement, and remedy is arguably even more acute. And this brings us to the question of what role arbitration could play in remedying rampant human rights abuses at sea. In spring 2020, the charity Human Rights at Sea, together with the law firm Shearman and Sterling, published a white paper, and in that white paper they suggest to establish a standalone institutional system of international arbitration that is specifically tailored to the specificities and complexities of human rights abuses at sea. The proposed system is victim-centered, so it will put the enforcement of human rights violations in the hands of victims by giving them the right to bring direct claims against alleged responsible persons or parties. Professor Kriebaum will provide us insights into how arbitration can ensure an effective remedy against human rights abuses at sea and thus empower victims of human rights abuses. In a last step, we further zoom in, and Professor Gaillard will turn to two key challenges relating to human rights at sea arbitration. First, he will focus on consent, which is a cornerstone of arbitration. We will learn more about how consent can be secured in this specific constellation, or maybe I should speak of specific constellations that we face in the maritime context. Furthermore, he will explore the issue of the enforceability of the award, which is key in a quest to establish a system which is supposed to give international law teeth, as the title of our panel alludes to. Each panelist will speak for about 8 minutes. That means that at the conclusion of the presentation, we will have some time for questions and discussions, and I encourage attendees to make use of the Q&A function to submit questions to the panelists. With this, I will introduce our first speaker, Elisabeth Mavropoulou. She's a qualified Greek lawyer. She holds an undergraduate law degree from the University of Athens and a postgraduate degree in international law from the University of Westminster. This month, she submitted her PhD thesis on international cooperation for refugees. Congratulations on that. She's a part-time visiting lecturer at the University of Westminster and a tutor at the Master Program of Refugee Law Initiative of the University of London. Outside academia, Elisabeth has been with Human Rights at Sea since 2014, so since the very beginning of the charity's life, and right now she's the charity's program manager. The title of her presentation is Arbitration as an Alternative Route for Effective Remedy for Human Rights Abuses at Sea. Without further ado, I turn over to you.
Thank you, Anna. Thank you very much. Let me just share my screen. So you can all see my slides, I assume. So welcome, good afternoon, good evening, depending on when you are. I'd like to thank the organizers for putting together, and particularly Shearman and Sterling and Arbitration Place for putting together this panel. I'm very excited to be on and giving the opportunity to talk on such a fascinating topic. My presentation, as Anna said, it will focus more on introducing the scope of the problem of human rights abuses at sea from a factual standpoint, but also, most importantly, from an NGO and civil society perspective. So if I may start with a few words about Human Rights at Sea as an organization. Human Rights at Sea was established in 2014, founded by David Hammond, practicing barrister at the time, who after an extensive gap analysis found that there was no available information in the public domain nor any civil society platform on the application of human rights abuses at sea, outside, of course, academic discourse and academic publications. In 2015, Human Rights at Sea became a charity in England and Wales, and since then we are driving the narrative and the concept of these 4 words, human rights at sea, internationally. Our founding principle is that human rights apply at sea as equally as they do on land. On that basis, of that principle, we advocate that all persons at sea, without distinction, enjoy their human rights. There are no maritime specific rules allowing for derogation from human rights standards. And finally, that all human rights established under treaty and customary law must be respected at sea. Our mission is to explicitly raise awareness, implementation, and accountability of human rights provisions throughout the maritime environment, especially when these are currently absent, ignored, or being abused. Our vision is to end human rights abuse throughout the maritime environment. Through our research, education, advocacy, and objective lobbying, we have published over 60 publications, delivered over 30 case studies showcasing systematic abuses of human rights at sea, established the Global Missing Seafarers and Fishers Reporting Program, and finally affected legislative and policy change in 20 jurisdictions as seen on the map. We take a 4-pillar approach, so our work covers seafarers, the global shipping industry, fishers, global fisheries, migrants and refugees, and business and human rights. In other words, our work focuses on the global maritime population at sea. To contextualize a bit on the global maritime population at sea, I'd like to start with some statistics. Starting from the global shipping industry, 5% of the world annual income comes from commercial and seaborne trades. There are, one more slide. There are 1.6 million seafarers around the world working on board commercial ships, engaging in offshore and oil and gas activities, tourism, and other. Currently, we have 197 states operating at sea. That said, the global fishing industry, the numbers are even illuminating. We have 56 million people who are engaged in fish capture and aquaculture. We have 20 million persons who are full-time fishers, which means that the majority of the people at sea are fishers, and an estimated 20,000 of whom are children working at sea and in coastal fishing communities. Interestingly, 75% of the world's fishing vessels are found in Indonesia. Now, the global trends of forced displacement are equally important for the scope of human rights abuses at sea. According to UNHCR, 80 million people have been forced to flee their homes, and that number includes the ones who are internally displaced. There are 26 million refugees under the UNHCR's mandate, including the High Commissioner's mandate for the Palestinian refugees. And most importantly, the increasing number of people who use the seas as means for migration are of concern to the international community. Particularly, the shipping industry since 2015 saved about 50,000 migrants and refugees. And most recently, the tanker of Maersk Etienne was stranded in the Mediterranean Sea for 39 days because no state was given access to a port for disembarkation. For 2020, the sea arrivals to Italy, Greece, Cyprus, Spain, and Malta are 60,000. With that in mind, the present in increasing numbers of people on the seas and oceans generates a growing need for the protection of their human rights. Sadly, it is a harsh fact, however, that not all of them who are at sea found themselves under the effective jurisdiction of states who are capable but also willing to uphold their human rights. The result is that a great many who are vulnerable end up being abused, with those doing the abuse unfortunately escaping the consequences of their action. With this in mind, and in light of the significant growing evidence of the systematic abuse of human rights with disquieting impunity, in 2019, we developed the innovative concept, along with Shearman and Sterling, for using international arbitration as means for effective remedy for human rights abuses for individual victims. Our aim is to develop a victim-led and victim-focused arbitration process for effective remedy using international law's arbitration toolkit. To contextualize when we're discussing human rights abuses, I'd like to give you some of the examples that our organization has come across. To begin with, we have fishers who are held in slavery on fishing grounds, thousands of miles away from where they have been recruited. Fijian fishers in tuna longliners are working in freezing temperatures and as a result had their fingers amputated because of the frost. Seafarers' abandonment and non-payment of wages is an increasing phenomenon. Abandoned by shipping companies, those seafarers are left without salaries or compensation in foreign shores, effectively being deprived of the right to repatriate. Not to mention the situation of COVID-19 has exacerbated the impacts. Seafarers who are not able to return to work at sea and gain a meaningful employment have resulted in borrowing money, and the impact on their families and the crew themselves are profound. We believe that if continuous debt goes unchecked, that it might result in indentured servitude and exploitation. On the other side, we have produced case studies on missing disappearances on board, where private investigations are happening behind closed doors, leaving the family members often in the dark and without closure. The death of fishers observers is a very much worrying fact, and our ongoing work in the Western and Central Pacific has highlighted some gaps in human rights protection. We've seen migrants and refugees smuggling, human trafficking, and criminality, let alone refoulement, namely pushbacks on the high seas, pushbacks of individuals on the high seas in territories and in countries where they're likely to face persecution, torture, and ill and degrading treatment. And finally, abuses at sea take the form of sexual assaults on board of passenger carrying vessels who operate under the flags of states who have no means to monitor compliance with human rights standards. An example of that is the MC Divina case of Spanish water, which was a passenger carrying vessel on board of which a 70-year-old British girl got raped, and the judge in Valencia denied jurisdiction on the basis that the incident had happened outside territorial waters of Spain under a Panamanian flagged vessels. From an NGO and civil society perspective, we've seen that there is disquieting and impunity when it comes to human rights abuses and lack of access to effective remedy, that part of the problem is international laws overlapping and conflicting jurisdiction, as Irene will highlight in her presentation, but also coming across with seafarers, fishers, and other victims of human rights abuses. We'll see that there are practical challenges that they face, such as the lack of funds, language barriers, no communication with the employers. And to give an example of the multiple actors that they are involved in a commercial shipping dispute, we often see that the charterers, the insurance, the ship owners, the flag states, they all pursue their own interests and leaving the individual behind without lack of access to remedy. That's why we hope that a victim-oriented arbitration process for addressing human rights abuses at sea is the way forward of giving international law the necessary enforcement. Thank you very much, and I'm looking forward to the Q&A and the rest of the presentations.
Thank you very much, Elizabeth, for this excellent overview about human rights at sea. It's quite impressive to see these numbers of how many persons are at sea at one time. Thank you also very much for the insights into flagrant human rights violations at sea and for providing some reasons on why this may happen. It's also telling that the first NGO specifically dealing with human rights at sea was only founded in 2014, given the vast number of NGOs active in the field of human rights. After this factual part, we will now move into international law. Irene Papanikolaou is our next speaker. She's an associate professor of international law at the University of Milano Bicocca in Italy. She has previously worked in the UK at the University of Glasgow and the University of Oxford. Irene Papanikolaou conducts research and has published widely into international law, most notably, among others, about the law of the sea, maritime boundaries, environmental law, IHL, human rights law, and the protection of underwater cultural heritage. She's the author of a must-have book when it comes to human rights at sea. It's the book International Law and the Protection of People at Sea, published with OUP in 2018. And she's also among the first scholars who has inquired into gender and law of the sea and having edited a book on the topic. She has been a legal advisor for the Italian Ministry of Foreign Affairs, for other states and international organizations. Professor Papanikolaou will hold a presentation with the title Lack of Law or Lack of Enforcement, International Law and the Protection of People at Sea. With this, I pivot to you. You have to unmute.
Thank you very much, Anna. I always forget to unmute myself. Thank you very much also to the American branch of the International Law Association and to all the organizers of this event for the kind invitation. Good evening, good afternoon, good morning to everybody who is online at the moment. I will try to share my screen and I don't know if this works. And I'm going to speak about lack of law, lack of enforcement in the protection of people at sea through international law. Some basic questions are, do we have any law? Does this law bind states? Does this law benefit humans? And there are some clear answers, which, however, are not sufficient, as we will see in the end. First of all, what rights at sea? And the answer is quite clear: all human rights. Human rights apply at sea in the same way as they apply on land, as with Anna and other colleagues we have said in the Geneva Declaration on Human Rights at Sea, sponsored by Human Rights at Sea. There are international treaties, global treaties, such as the ICCPR and the ICESRCR, the European Convention of Human Rights, the American Convention of Human Rights, but also more specialized treaties such as labor treaties and so on. So there are no rights which in principle do not apply at sea, although one has to look at the specific elements of every case to determine which specific rights apply in any given case. Second, which people? And of course, human rights protect all people. Human rights are universal. They apply to seafarers, fishers, offshore workers, passengers, migrants, but also criminals, pirates, drug traffickers, and so on. However, we do have some special protection for specific categories, for example, children or refugees. So we have a whole of human rights that apply to all people, and we may have additional protection for specific categories because of their circumstances. And then, of course, we have rights. These rights apply to people, and who should protect them? Who should ensure that these rights are effectively enjoyed by the people? Of course, states. And which states? Any state that has jurisdiction. According to human rights law, jurisdiction may be de jure, so based on legal rules saying that a state has the power, the right, or the duty to do something. And we do have rules on the flag state, the coastal state, the port state, the state of nationality of the persons, but also specific rules deriving from bilateral or multilateral treaties entered into by states. And then we have de facto jurisdiction. So the actual control a state through its agents exercises over a vessel or over a person. Of course, if there is a person on the vessel, control over the vessel is sufficient to establish the jurisdiction of a state. And in this case, in all these cases, states that have jurisdiction have the duty to protect and ensure the enjoyment of all human rights. An issue, however, that has been raised recently concerning human rights at sea is the problem of omission. What about omissions? What about the states not doing anything? Not having clear de jure jurisdiction and not exercising de facto jurisdiction. A state that abstains from rescuing people in danger at sea is the typical example. A vessel in distress sends a system. This is captured by MRCCs. MRCCs may send out messages to other vessels, and then no one does anything. How do we determine which state has the duty on the basis of the jurisdictional link? This is something that is not yet clear. So we do have law. Law exists, law provides for human rights, law provides for the jurisdictional link, which links a state that must ensure human rights and a person who enjoys human rights. And then about remedies. How can we use these laws to address all the issues already raised by Elizabeth? Well, we do have some existing remedies, both under law of the sea and human rights law. So, for example, we do have some judges set out in the United Nations Convention on the Law of the Sea, but they present some problems. The International Court of Justice may hear cases only brought by states, so individuals and groups cannot bring cases to the ICJ. The International Tribunal for the Law of the Sea and Annex 7 arbitration give very limited place to individuals. We have the possibility of prompt release proceedings, which is a rather technical proceeding to ensure that the crew of a vessel is promptly released upon the posting of a reasonable bond. We do have some provisions concerning safeguard of rights for miners and other contractors in the international seabed area, but again, this is a very limited issue. And then we do have a rule about provisional measures, which, although not directly linked with individuals, has been used to safeguard human rights. But again, this requires the intervention of a state. And then we do have human rights judges, but the judges who exist, in particular the three human rights courts, the European Court, the Inter-American Court, and the African Court, are regional bodies. They are set up by states through treaties, and as a well-established rule of international law says, only states which are parties to a treaty are bound by the treaty. So only states which have accepted the jurisdiction of these courts can be asked to account for their actions or omissions in front of these courts. And not all states, in particular in the American and African regions, have accepted the jurisdiction of these courts. And then we have global quasi-judges, such as the Human Rights Commission, but these are non-binding bodies. So they don't have binding decisions. And the fact that any report they make is not binding has practical consequences at the state level because it cannot be enforced in any way. Finally, I should mention that we do have national judges, and so far much protection has been granted through national judges. For example, we have had cases in Italy in which national judges ruled against the acts of the government that violated the rights of irregular migrants by sea and those who are saving them. But national judges often do not have specific expertise. And I should say, well, very few people have specific expertise. This panel is exceptional in bringing together some of the very few people who have made the human rights at sea their main object of study, research, and work. But also we have jurisdictional issues. Even when a state is a party to a treaty, this state has not necessarily extended the jurisdiction of its courts to examine issues happening extraterritorially, that is, outside from the territory of the state. Jurisdiction, of course, is usually territorial. It is limited to the territory of the state. At most, it is extended to vessels flying the flag of a state. And then we have lots of procedural issues as well. So, yes, we do have some judges who can adjudicate, but they all present drawbacks. And this brings me to the final slide and the conclusions of my presentation. So we do have human rights. Human rights exist, they apply at sea the same way they apply on land. They bind states that have jurisdiction over a specific person. But first of all, they need jurisdiction to be applicable. So we do have the issue of omissions to which I was pointing out before. They need courts to judge them. And as we have seen, we do have a great lack of competent judges, both internationally and nationally. And finally, they need states to enforce them. Even when we have a decision by a court, a judgment, then this needs to be enforced. And there are issues in enforcing international judgments. There are issues in enforcing national judgments in states other than the state that has adopted the decision, and all these need to be addressed. So I know I am concluding on a rather pessimist note, but my main objective has been to highlight the problems, and I'm sure that the next speakers will bring solutions to these problems. Thank you very much for your attention.
Thank you very much, Professor Papanikolaou, for setting the stage in terms of international law. It was a very clear presentation highlighting the sources, the beneficiaries of rights at sea, but also highlighting that currently existing remedies have various shortcomings as regards limited jurisdiction or limited geographical reach. And as you mentioned, you concluded on a rather pessimistic note, and that brings us to the next presentation, which is entitled Arbitration as Remedy for Human Rights Abuses. And I hope that Professor Kriebaum can offer us some, at least some solutions or a partial solution to in terms of effective remedy of human rights abuses at sea. Dr. Ursula Kriebaum, she's also professor of international law at the University of Vienna. She was a member of the drafting team of the Hague Rules on Business and Human Rights Arbitration, and is also a member of the Permanent Court of Arbitration. She teaches various subjects of international law, notably investment law and human rights law at the University of Vienna, and she's acting as a legal expert in international investment law and human rights law cases. She has also been a consultant for law firms, also in the area of investment law and arbitration, and she has published widely on human rights law and international investment law. Professor Kriebaum, the floor is yours.
Thank you very much for the kind introduction, and thank you very much for the invitation to take part in this interesting panel. Arbitration as a remedy for human rights abuses. Well, disputes over practices of businesses, and they are usually the ones that are the origin of the human rights abuses, can be solved through a number of techniques ranging from negotiation through mediation all the way to litigation in numerous venues. They're basically two addressees for the claims, the states and the businesses. I mean, businesses are not everywhere at the origin of human rights violations, but in our context and law of the sea, all the examples that have been mentioned were examples where actually businesses were at the origin of the problem. The limits concerning holding accountable states have just been pointed out by Professor Papanikolaou. Individuals attempting to enforce human rights obligations vis-a-vis businesses also face difficulties, for instance, when they attempt to use national courts. So the courts in the country where the alleged human rights abuses took place may be unable to fairly adjudicate the case. The parent company of an entity responsible for a human rights abuse may be insulated from liability for the alleged abuses due to jurisdictional obstacles or legal principles. Costs may be too high. International human rights courts, as we have heard, or treaty monitoring bodies are not available if you want to hold a business accountable, since only states can be held accountable in front of them. Courts in other countries, especially in the US, are no longer available for victims of human rights abuses without a sufficient nexus to the United States. 2013, the US Supreme Court ruled in Kriebaum versus Shell that the US Alien Tort Statute of 1789 has no extraterritorial effect. It denied victims of human rights abuses by companies access to US courts to obtain damages for alleged violations. As a consequence, the idea arose that arbitration could be used as an alternative route for dispute resolution available to right holders and to corporations to resolve their disputes in the business and human rights field. It can provide a remedy for victims of human rights abuses by companies where alternative avenues are not available or adequate. Business and human rights arbitration can offer a neutral forum for dispute resolution that is independent from the parties as well as from their home states. A specialized dispute resolution process in which the parties are able to participate in the selection of the adjudicators of their dispute. They can therefore select arbitrators that are experts in the field in dispute, for example, human rights in the mining, shipping, oil, or garment industry. The possibility to obtain binding awards subjected only to limited judicial review and enforceable across borders in many states. a dispute settlement mechanism that is potentially cheaper and quicker than litigation, and a dispute settlement mechanism that offers parties broad autonomy to adapt it to their needs. Arbitration in some cases may be the only remedy available for victims of human rights abuses by businesses. For businesses, arbitration has the advantage to assist them in meeting their responsibilities under the United Nations Guiding Principles on Business and Human Rights. Pillar 2, namely the obligation to offer a remedy to victims of human rights abuses. Pillar 3 of the UN Guiding Principles, the victims' access to an effective remedy, has been given less attention so far. That is where arbitration could close a gap. Arbitration can provide a non-state-based, non-judicial remedy for victims ex post under Pillar 3 of the UN Guiding Principles. At the same time, arbitration can offer businesses a possibility to fulfill their obligations under Pillar 2 to ex ante offer a remedy for human rights abuses committed by them or in their supply chain. However, compared to traditional arbitration between private parties, business and human rights arbitration has special needs. One set of rules, which is now nearly a year old and which has been specifically adapted for arbitrating business and human rights disputes, are the Hague Rules on Business and Human Rights Arbitration. These rules are based on the arbitration rules of the United Nations Commission on International Trade Law, and they have been adapted in order to reflect the particular characteristics of disputes related to the human rights impact of businesses, the potential imbalance of power that may arise in business and human rights disputes, the public interest in the resolution of such disputes, which may require, among other things, a high degree of transparency of the proceedings, and the importance of having arbitrators with expertise for this type of disputes. The possible need for the arbitral tribunal to create special mechanisms for the gathering of evidence and the protection of witnesses. Therefore, the Hague Rules contain various provisions that deal with issues of inequality of arms between the potential parties of a dispute. One such example is an article dealing with representation and assistance. It responds to the potential inequality of arms among the disputing parties that may have a negative impact on the overall fairness of the arbitration proceedings. It deals with inequalities that create barriers to access to a remedy, such as lack of adequate representation, language problems, costs, and fears of reprisals. The article allows, for example, in appropriate cases for more proactive and inquisitorial as opposed to adversarial procedures. Adjustments concerning statements of claims and taking of evidence have been included in the rules to allow for an adequate response to a potential inequality of arms. The same is true for the rules on fees and expenses of arbitrators and allocation of costs. There, the tribunal can take into account situations of economic imbalance, and the model clauses annexed to the rules provide examples for cost shifting provisions. The rule on applicable law was also adapted to the needs of business and human rights arbitration. It has to offer legal security and predictability concerning the outcome of arbitration proceedings. On the other hand, the rules need to be flexible enough to deal with a variety of legal instruments that can potentially contain substantive human rights standards relevant for business and human rights disputes, such as domestic law, contracts, human rights treaties, and certain soft law standards. Another field where adaptations were necessary are the rules in connection with the protection of parties or their representatives in exceptional cases. The UN article empowers the tribunal to protect the confidentiality of the identity of a party or its representatives vis-à-vis other parties. This may be necessary where the disclosure of such identity is sensitive or may otherwise prejudice that party or its representatives. In such a situation, the tribunal may designate a specific representative of the other party who may be informed of the identity of a party or the representative of a party who requests such designation. All representatives so designated shall, of course, observe confidentiality in connection with this identity. Another article contains provisions for the protection of witnesses in situations of genuine fear. Specific measures that the tribunal can use may include the non-disclosure to the public or to the other party of the identity or whereabouts of a witness. Because of the public interest in these types of dispute and learning from the experience in investment arbitration, the rules contain new provisions on transparency while providing for model clauses that give the parties the option to choose their own procedures. Further changes to the UNCITRAL rules concern issues like the selection of arbitrators with appropriate expertise for business and human rights disputes, as well as a special code of conduct for arbitrators. Furthermore, given the context in which the rules shall be applied, they require that the tribunal satisfies itself that an award is human rights compatible. If one would want to use arbitration as a remedy between the individual victims and states, the applicable law would probably be the existing human rights treaties, but many of the adaptations that we made for business and human rights disputes would also be beneficial in the context of arbitration between individual victims and states. Therefore, if properly adapted to the specific needs of business and human rights disputes, arbitration can provide a useful alternative remedy, sometimes the only remedy for victims of human rights abuses by businesses. But as we will learn from our next speaker, one of the more critical things is how you get consent, either by businesses or by states, if that is envisioned. Thank you very much.
Thank you very much, Professor Kriebaum, for highlighting various procedural issues which the procedure needs to be adapted to the specific situation we have. There is a striking imbalance of power between the involved parties and equality of arms, as you referred to it. And it was very enlightening to hear all the specificities of the Hague rules on business and human rights arbitration, which counterbalance that imbalance slightly. With this, we turn to the next speaker. For those who do arbitration, it's certainly a familiar name. Emmanuel Gaillard is the global head of disputes and global head of the International Arbitration Practice Group at Shearman and Sterling. He's recognized as a leading academic in the field of commercial arbitration and investment treaty arbitration. He's a professor of law, not only in France, but also a visiting professor at Harvard Law School and Yale Law School, where he teaches investment and commercial arbitration law. The title of his presentation is Challenges of Human Rights at Sea Arbitration, Consent and Enforcement. Over to you.
Thank you, Anna. Indeed, it's two difficult topics. And when Human Rights at Sea came to see us and discuss the possibility to use arbitration to redress some of the, or to address actually some of the challenges Human Rights at Sea present, we thought it was a great idea. And we were happy to help on a pro bono basis. And that's one of the great pro bono projects the firm is doing at the moment. And it's particularly challenging. And the two issues which are the most challenging with the idea to use arbitration to address human rights abuses at sea is how to secure consent. And that's the difficult issue, that's the core of the difficulty. And then once you have secured consent, then the reward, I would say, is that you can rather easily enforce an award, i.e. the product of the arbitral tribunal activity internationally. So I will address in terms very briefly, because it's really to open the discussion, these two issues: how do you secure consent, and how do you enforce the result? First, how to secure consent. Well, arbitration traditionally is based on consent, and the typical arbitration agreement is an arbitration agreement which is found in a contract between two parties, a sales contract, a license, mining, whatever, long-term gas sales contract, whatever, generally in a business context. And in the contract itself, both parties agree that disputes will be arbitrated. That's the traditional model. That's why it's arbitration and consent really go together. It's a dogma, it's a foundation of arbitration, it's a cornerstone of arbitration. There is no arbitration without an agreement to arbitrate. It's not mandatory, it's voluntary, it's on the basis of an agreement to arbitrate. And if you take both parties in isolation, or both or more, everybody has consented. There is an arbitration agreement. That's the traditional model of arbitration. Now, that said, one has to recognize that today, and that's my next slide today, I mean, this is a quote from Gabriel Kaufmann and Thomas Schultz. Today, you see the consent has evolved. And it's not the traditional, it's not only the traditional consent, which you find in just a sales contract where the buyer and the seller both consent that if there is a problem regarding this contract, they will arbitrate the disputes. You have, in a complex world, you have different forms of consent. You have different types of arbitration. And you have, for instance, this sales contract can be transferred to a third party. The third party benefits from it. Will they be bound by the arbitration agreement? The consent is still there, but diversified, and there is less emphasis on consent in a number of situations. Certain states have also decided to make arbitration mandatory. So you have certain mandatory forms of arbitration, and to me, to a certain degree, it's a misnomer because arbitration is based on consent and it's mandatory. It's a bit weird. Now, you have a couple of examples I would like to give by way of background. The first one is CAS. It's the field of sports arbitration. And of course, when an athlete wants to participate in any competition, they have to accept the rules of the game. They have to accept a certain, it's a certain type of rules, and they have to accept that any dispute which will arise from this competition will be decided by CAS, by a certain sports tribunal. And here, the consent is there in theory, because if you want to participate in the race, you have to consent. But it's a strange form of consent, because to participate, of course you want to participate, of course you're an athlete, of course you want to participate in the games, and you will consent. Now, is it still arbitration? Well, the Swiss Federal Tribunal says, yes, it's still arbitration. This still works. It's consent. It's maybe there is no option. Maybe it's a bit of a forced consent, but it's still consent. So it's still arbitration, right? Now, another model, which is also, and stay on this slide, maybe, on the next slide, it doesn't matter. So another form of arbitration, which let's move to the next slide, which is it's investment arbitration. It's very far from human rights, and if anything, NGOs say it's terrible, and it's a way to abuse states, which is a gross exaggeration. And in any event, I'm not going to discuss that here. But what's interesting here, it's not the merits of investment arbitration or lack thereof. It's what's interesting is the way it works and what consent is in an investor-state relationship. Now, in investor-state relationships, you also have the traditional type of consent. You have a mining license. The state accepts an investment in mining, and they in a contract, they say we will arbitrate the disputes. That's still very traditional. But you also have consent given in legislation. I will protect a class of investor if they come invest in my country. I say that in my law, or in a bilateral investment treaty, in a multilateral investment treaty, or in the investment chapter of a free trade agreement. And here, the interesting concept is that these treaties, these laws do couple a certain protection of the investor in order to attract investment in the country in question. They couple a regime of protection with an offer to arbitrate. So these treaties basically say, I will not expropriate, I will deal with this investment in such and such a way. That's the substantive regime. And if the beneficiary of this protection, the investor of the other country or the other countries in multilateral agreements, think that I have violated this substantive regime, they can start an arbitration against me. So it's a way to couple a substantive protection with an offer to arbitrate. And the offer to arbitrate is addressed not to one party like in a traditional arbitration agreement, the other party to the agreement or the other parties to the same agreement. It's offered to a class of investors, which is unknown. It's defined as a class, but the actual investors who will be the beneficiaries are unknown when the state says, I will protect. So it's Venezuela says, I will protect the French investors in a bilateral treaty between Venezuela and France, right? So it's a class of investor who is the beneficiary. So what's key here is the consent is dissociated in that it's given at the time of the treaty being applicable or entered into by the state, and the investor can accept the consent, can consent also, but years later when they say, yes, oh, I'm a French investor, oh, I had a problem in Venezuela, there is a BIT between France, not me, and Venezuela, and I'm protected by that, therefore I can start the arbitration. The consent was given by the state in the treaty, and the consent of the consent of the state was given. The consent of the investor is given in later when they start the arbitration. Yes, I need protection. I was expropriated. I start the action. Now, this is this model, which we think can be used in the context of human rights at sea protection, in a system which has to be, and there are other features which have to be victim-centric. So it should create lots of options for the victim. Nothing should be mandatory for the victim. The victim. Now, if the ship owners, if all the potential violators of human rights at sea, that's the key difficulty, have pledged in advance to respect human rights, but as Irene said, the human rights are applicable at sea. The problem is not so much the substantive law itself. It's pretty easy to say, well, there are lots of treaties and rules which apply at sea, in theory. The problem is the practice and the judge who would decide that. So if we can somehow secure the consent of the players to couple the protection with a general offer to arbitrate, then the victim could say, and generally they don't know in advance, NGOs are telling them, well, you have this, maybe you want to use it. If that they can consent afterwards, if they think that it's going to help them, if they want to go elsewhere, they can, it's just optional, but that would be a fantastic option. Now, so you would have the same system as in investment arbitration, the victims giving their consent to arbitrate, and the perpetrators having given the consent in advance. Now, the big question is not the consent of the victims. The big question is the consent of the perpetrators. Why should a human rights abuser consent to arbitration in advance? Well, I think the answer there, and we can all brainstorm on this, is carrot and stick. You can shame certain governments. I think that's how the law advances in certain areas. That's true for environment. Of course, it's cheaper to have goods manufactured by children in a far state. But some companies are saying, well, we are not doing that anymore because people are prepared to pay a little more to have goods which are not being manufactured by children in slavery conditions. So that shaming can be an aspect. International negotiations can be an aspect. Of course, the flag states have to play a big role in this. If the flag states were to say, I will give you my flag only if you accept to abide by certain rules, that would be huge progress. And why would they do that? Because of course they want to sell their flag by being willfully blind, because of the pressure other states can put on those states. So that's the stick. Now the carrot, I think, can be equally interesting, and the carrot can be financing. And certain banks, all in this industry, all the players need money. And if the banks or the financing institutions having a social and corporate governance or having this mindset are saying, I'm going to finance the building of your ship if you accept and you make down the chain, you make every player accept this pledge, which would be a generally accepted pledge, coupled with this arbitration offer, then that's a big incentive. And I don't think it's completely impossible. It will be starting with the financial institutions, and we know for sure that some want to finance only if they are sure that the financing will be used in a legitimate, not in a legitimate way, or for not to finance activities which will end up with a race to the bottom. And that's an incentive. So financing incentive, flag states, ports could say, well, I can let you in if you participate in the system. If you have this kind of pledge, I let you in, or I lower the fare, or I don't let you in if you don't abide by these rules. So it's a bit difficult to implement, but you can, and I will leave it there at the moment, you can certainly think of certain incentives. So again, incentive, naming and shaming, carrot and stick approach. That's, if you secure consent, and I'm not suggesting, and I will tell you why in a minute, I'm not suggesting that making mandatory arbitration would work. Mandatory arbitration is a misnomer, and you need consent, even if the consent is a little bit not completely spontaneous, like we have seen in the sport context. Now, the benefit now, if you can secure the consent to a system like the one we suggest, the benefit is enforceability. And here I talk about enforceability in terms of enforcement of the award, the decision of the arbitral tribunal, who can follow the Hague rule or specific set of rules, but the Hague rules are very interesting. And the result of the decision is an award. The award is enforceable, and I'm going to talk about for 1 minute about the enforceability of, in that sense, not in the enforceability of the regime in the sense of what Stephen Haynes asked as a question to the panel, like how do you police, how do you make sure that there is no abuse at sea, and we can address that in the discussion later. but I'm talking about the enforcement of the result of the arbitration activity, i.e. the award. Now, if we have consent, if we have an arbitral decision, then it will be enforceable, and that's my next slide. It will be enforceable because, oddly enough, it's easier to enforce an award rendered by a private tribunal, arbitral tribunal, than to enforce a court decision in the world. Today, 165 states, that's a huge success, have accepted the New York Convention. You can look at our website. This is another pro bono project of Shearman and Sterling, New York, the New York Convention 1958.org, where we put all the decisions on the New York Convention for free on a website, freely accessible. And you have this fantastic instrument to enforce international awards. Now here you have a little twist, which is that 52 states, you have the possibility of making a commercial reservation to say, I will enforce awards without review on the merits, but only if it's commercial. If it's another type of arbitration, I do not, it's not that I will refuse the award, but I do not have to follow the New York Convention. I'm not bound by the New York Convention. And here there's a twist, but even if you subtract 52 states, that's still a huge number of states who are prepared to recognize arbitral awards, even if they are not between merchants, even if we are not in the commercial sphere. So enforcement, I think it's not going to be too difficult if we secure consent in the first place. And if you go to the next slide, well, or not actually, maybe we can stay on this. Simply, the reason why I said earlier that you do not want to go as far as forced consent is that if you have forced consent, then it's not an award anymore, and it doesn't benefit from the New York Convention, because to benefit from the New York Convention, you have to have a true award, which means a true award rendered on the basis of an arbitration agreement, which is the agreement to arbitrate. It doesn't have to be in the same instrument, everybody consenting in a traditional contract. It can be dissociated consent. Everybody accepts that today. But you have to have consent on both sides. If not, it's not an award, and the New York Convention is lost. So the difficulty is consent. The benefit is the New York Convention. That's why arbitration is a promising avenue if we can secure consent of the major players through a carrot and stick approach. Thank you for your.
Thank you very much, Professor Gaillard, for these insights. It's very interesting to learn more about how consent could be secured, especially in an environment where we have a bit of a race to the bottom culture with the flags of convenience, etc. We are already a bit past 3 o'clock, but I guess there is a little time left for some questions. As regards securing consent, I was wondering, and maybe this goes to Elisabeth Mavropoulou, the question, what could be the role of NGO in this carrot and stick, if we use that carrot and stick metaphor, what role could NGOs have in helping secure consent? Then a question which is maybe more for Professor Kriebaum and Gaillard. We have these Hague rules on business and human rights arbitration. Do you think that would be an applicable framework, or do the maritime specificities need a tailor-made framework, a specific framework for arbitration? And then for Professor Papanikolaou, in terms of substantive rules, you spoke about omissions, that states refrain from acting because they argue that another state is competent. Do you think a clarification of which state is responsible, flag state, coastal state, port state, etc., maybe through a soft law approach could be beneficial, could help like filling that gap or avoiding that they just shift responsibilities around? Then now, Elisabeth Mavropoulou, do you want to start? And please keep the answer short because we have just some minutes left. Thank you.
I know. Thank you for the question. I'll be short. I believe that as a civil society organization and NGOs do work through advocacy to persuade and to gain participants and partners in this endeavor. I would say, apart from the sticks approach, which will work with naming and shaming, I would go down the road of trying to persuade those who wants to do good business to form a coalition of the willing and lead in this initiative. There are many business that we have talked to that they want to go with clean hands, and I don't think it's impossible. It might seem impossible to secure the consent, but there are those who are willing to do so and lead because they know their legacy, because of their corporate social responsibility when it comes to banks. So I think outside the sticks approach, who could work alongside the carrots, I will go for the carrots and go towards advocacy and persuasion.
Thank you very much. I just see at the chat that at 3:10 our room closes automatically, so I fear that we don't have a lot of time to answer the question. Before being cut off, I would like to thank the organizers for hosting this panel, the American branch of the International Law Association. I would also like to thank the panelists for all the insights they provided us. And of course, many thanks to the audience for attending the session. I hope that you will have an inspiring remainder of the International Law Weekend. And I sincerely hope that there will be another forum where we can discuss all these issues. I guess we could easily continue for another hour or more. And I hope that was just the start of what's still lying ahead of us. Thank you very much, and have a nice afternoon, or for the panelists, have a nice evening. Thank you very much.
Thank you.
Thank you, Anna. Thank you, everybody. Thank you.
Thank you, everybody. Thank you, Anna.